Friends, we are going to discuss today the most important topic where banking industry and the corporate world is disturbed because of certain unwarranted events which were happened in the industry. The law-making authorities, which helps to both the entities like bankers as well as the companies, and those companies ultimately finding out certain ways to protect themselves, and bankers or financial institution trying to get their position well secured. With this introduction, you will come to know that the today's topic for the discussion is Insolvency and Bankruptcy Code, which is recently introduced by the Government of India by way of bill or law in 2016. I am not saying that I am expert in this area, but my name is Abasaheb Chavan. I have working experience with the banks for more than 40 years, and I have come across with the situations which are pertinent and relevant to the insolvency by the clients and the bankruptcy which the people have already made and bankers are suffered. I have practically handled these situations. That is why I feel that I can throw more light on this particular subjects, that is Insolvency and Bankruptcy Code 2016. So, for this, my presentation flow will be to take you through the framework for the insolvency and the bankruptcy prior to introduction of IBC, that is Insolvency and Bankruptcy Code. Then the simple question, why Insolvency and Bankruptcy Code 2016 was required? Was it necessary? Then pitfalls and tactics which are adopted by the various people, banks, corporates under the existing regime, and what is proposed basis on the experience taken by the law, experience by the bankers, and when they came across in dealing with such kind of cases with the corporates, and the introduction of the IBC, that is Insolvency and Bankruptcy Code, structure of the bankruptcy, structure of the Insolvency and the Bankruptcy Code, then coming to institutional framework of IBC, then constitution, roles and responsibilities in the new IBC, then key aspects, what is covered under Insolvency and the Bankruptcy Code, then key points on the insolvency resolution process. There are 2-3 points, phases, particularly for the corporates. Then moving forward for the time-bound insolvency process, within the certain time framework, one has to, or the authority has to crystallize everything, and the corporate insolvency resolution process phase 1 and phase 2, which will be continued after the fast track resolution process also we are going to discuss. And once the resolution process is completed, then comes the liquidation process, or liquidation of the whatever is seized during the process, then voluntary liquidation, then distribution of assets and waterfall mechanism, continuation with the adjudication, then offences and penalties, and moreover despite all these processes defined, various sections, various laws and various other things are made strict, there are certain challenges to the industry as well as the bankers. Then after completing the corporates, we will move slowly towards the cross-border insolvency. Then personal insolvency, followed by insolvency resolution process and bankruptcy, as well as highlighting the new opportunity and the scope of these opportunities in the industry for the people like you and me, and comparing to the bankruptcy law, which is after introduction of the IBC and currently what is happening or in place in US. And finally, I am touching to the what does the code mean for the international creditors borrowing from the overseas. Those aspects also we are going to cover, and we will conclude this presentation. Let us understand first the framework for insolvency and bankruptcy before introduction of the Insolvency and Bankruptcy Code 2016. First, let us understand what do you mean by the code. The code, Black Law Dictionary, defined as collection and compendium of law. So bankruptcy code, in that code means the collection of various laws which are pertaining to the subject. In legal parlance, it refers to the systematic and comprehensive compilation of the law, rules, regulations, and that are to be consolidated and classified according to the particular subject matter. Bankruptcy code, which is nothing but a comprehensive compilation of the laws, rules, regulation pertaining to the subject of bankruptcy in India, and no single umbrella, you are aware that no single umbrella of the legislation governs the insolvency and bankruptcy proceedings in India, and instead of there are various laws, slew of laws, various number of laws are there governing the legal framework, and those framework consist of some of the laws which I can narrate is, one is Companies Law 2013, then Sikh Industrial Companies Special Provision Act of 1985, then Recovery of Debts and Recovery of the Debt due to the Bank and Financial Institution Act 1993. Then next law will be the Securities and Reconstruction of the Financial Assets and Enforcement of the Security Interest Act 2002, which is popularly known as SARFAESI Act. And next one will be the Presidency Town Insolvency Act 1909, Provincial Insolvency Act 1920, and the forums such as the Debt Recovery Tribunal, that is DRT, and the Companies Court and the National Company Law Tribunal, and the single piece of legislation to connect the various insolvency laws has been on the card for some time. Now, these are about 6, 7 or 8 laws. These are in place. Which law is to be referred, which has an overriding impact on other laws. So, all this is the complex process. Whenever insolvency happens or bankruptcy happens, first to start with, from where to start, who has to take a lead. It's a very complex situation before the law authority, as well as to court, as well as to the bank, as well as to the companies also. And there is no single piece of legislation as such. Various laws, various amendments to it, various so many things comes under this. So it was felt necessary by the law-making authority that there should be a single piece of law which will be applicable for any kind of insolvency, any kind of bankruptcy, and the process should be time bound, and within the shortest possible time it should be resolved. That is what ultimate aim of this particular IBC is. As I said, there are various issues in the current system. Just going through one by one, you will understand that how tedious is the process of resolution of insolvency and the bankruptcy. The reason for the new introduction of 2016 Insolvency and the Bankruptcy Code is, first one, the current Indian bankruptcy regime is highly fragmented, having multiple judiciary forum, which is resulting into the clarity to the matter. Followed by the decisions which are taken are often appealed, then stayed or overturned by the judiciary forum itself. So there is no end. Delay in closure of unviable business, since the standstill mechanism has been misused by the corporate debtors also. Secured and unsecured creditors, employees, regulatory authorities have different and often different competing rights with no common regulatory process to determine the priority of the claim. Each and every individual, corporates, judiciary authority, lawmaking authority, they are all the time they are referring to different laws which are in place. Lack of credible data regarding the assets, indebtedness, as well as the security situation of the companies. At one go, no one will be getting this data on particular time bound, that is real time basis. And that is also one of the most important reasons, because once the assets are assessed so as to determine and evaluate it, so as to liquidate and ensure whether it can cover the insolvent amount or bankrupt amount, what the bank under this code, whatever the amount is there, whether recovery is possible, and up to, if it is possible, then up to what extent it can be possible. So the data is very much important on that too, on real time it is very much required, and again it has to be disposed within the time bound manner. Otherwise the value of the assets may change, and assets may be floating assets, current asset, or it may be capital assets. The entire process of winding up is very long winded, with court, debt recovery tribunal, that is DRT, and the Board of Industrial and Financial Reconstruction, that is BIFR, and all having to say in the process. Because everybody, DRT, BIFR, or maybe courts or any other tribunal, wherever the cases of bankruptcy are there and it is getting investigated, and so as to penalize the erring borrower and give a safeguard to the financial institution of the banks. See, these are some of the reasons so as to come out of all this particular code, that is Insolvency and Bankruptcy Code, is very much needed. The current system also does not address the interest of unsecured creditors. There are two types of creditors: secured creditors and unsecured creditors. Unsecured creditors, more particularly like bondholders, where there is no security as such and it's only the loan given, and foreign creditors or institutions other than the bank or non-banking financial companies, NBFCs, as well as the creditor would also not esteemed by the red tape promoter will be directly become an accountable for the financial lapses, fixing the accountability within the company or corporates is the most important part. So many times these promoters are also getting penalized. The code, by forcing it, failed the firms to shutter the shop and lead to the survival of the fittest in the job market too. For example, good example and recent past example is the Kingfisher, once India's second biggest airline, was grounded in 2012. Why? With debt of over approximately $1.5 billion, but it was not until recently, that is this month, February of this year, that its long-suffering creditor banks, those who have financed to it, has got nothing in their hand. So this is very good example to understand why the Bankruptcy Code 2016 is required. Now, continuing with why the IBC, that is Insolvency and Bankruptcy Code, is required. In continuation of it, if we look at the statistic and compare what is happening in other country and what is the time taken to resolve the cases, if you compare, you will understand that in general, the average time taken to resolve the insolvency is a very long. And if you look at the chart here, the chart here, you say the time taken here for India is 4.3, that is 4 years, 3 months, average I am talking about. That is what I said, 4.5, 4.4, that is 4 to 4.5 years as compared to 0.08 years, means just 8 months in respect of the Singapore. If you look at the Singapore or Hong Kong particularly, you will find that within 8 months, and lowest time taken to resolve the cases of the bankruptcy or insolvency is Japan. And highest time taken here is India. And this is felt necessary that there should be, this time gap must be reduced, and that's the reason why the Insolvency and Bankruptcy Code is required. This is one aspect of time taken. If you look at the correct position of the recovery rate, what is the position? Now look at the recovery rate also. I am talking about the current position under current law, not under IBC regime. India has, earlier we have seen the picture where time taken we have taken into consideration. Now we are taken into consideration recovery rate. Now, after the insolvency process is completed, how much time or how much amount is recovered? That is most important. Whether it is 100% recovery, I don't know. But if you compare the worldwide data, then you see the lowest recovery rate is here in Philippines and followed by the India. 25.7% assets valuation is only getting recovered by the financial institution or creditors. But if you look at again to Japan, almost 93%, very high recovery rate is there. And that is happened only because of the single law in place in Japan and most of the other countries like Singapore, Hong Kong, and all other countries, as well as, and if you consider here Philippines, India and Indonesia, and as well as China also. China still 36%, little bit better than the India, but 25%, 7% is very, very low. 25% you have to, 75% you have to lose, and 25% you have to recover. What is the use? And all this what is recovered, that may be spent on making the payment for the law authority or other process involved in that, into that. So ultimately there is, I can say, not even 25%, but it must be less than that. So that is the reason why the IBC is required. I quoted the example of the Kingfisher. What exactly happened in the Kingfisher airline, do you know? If you look at in 2005, the Kingfisher airline, that is a grounded, and if you look process here at this stage, 5 new Airbus, despite there is a loss, 5 new Airbuses were asked for. Then it comes another 26%, another 36 Airbuses are also again ordered. So it so happened that all the time loss is sustained, and finally the stage has come where bankers are demanding or creditors are demanding, and despite knowing the losses, even bankers are also forced to grant the additional advance or additional loan to this company despite knowing the losses. Finally the stage come that there was a low turnover and it is grounded, that Kingfisher airline was grounded and operation was stopped because there are many issues happened. One, bankruptcy. Second one, the employees of the company are getting suffered. They were not paid sufficiently, sufficiently in time. So all these events happened, and finally what happened, the promoter director, despite he was in the country, the process, judiciary process was on. By virtue of the pitfalls in the law, he is allowed to go overseas. And now what is the situation that everybody knows? That promoter or director is not available in the country, and he is saying he is off the hand. He is saying the company itself is a legal entity and the contribution of the promoter is a distinct from the company, and he is liable only to the extent of whatever the stake he is having in the company. Minimum stake, but whose money is ultimately gone? It is all equity holders, those who have invested in this company. And again, in addition to that, the bankers who financed them, they have also lost. They have also burned their hands. I am not saying burned the fingers, but burned the hand. And this is one of the best example to quote why there is a need to change the law. And that is why this bankruptcy code came into existence. While understanding this type of case studies, you may come across with the situation to understand what are the pitfalls and the tactics which are normally played by these people. Starting with the defaulting promoters, he may be willful defaulters or otherwise, and he is trying to hide behind the shield of the law which provides and protects him, treating a company as a separate legal entity and distinct from its promoters, shareholders and directors. This is one of the pitfalls. Second one is, trick of many defaulters is that following the doctrine of the limited liability principle, the law recognizes that the liability of the shareholders of the company is limited to the extent of its own contribution, which I have already explained while explaining the example of the Kingfisher. When the lenders turn on to the hit, the defaulters take a right on the tricky overburdened bankruptcy and insolvency system, and the piercing the corporate veil for the default may have the chilling effect on entrepreneurial activity, and the courts appears to be conscious of this. Then troubled companies in India, they are, or their creditors, they are largely turned down to the official liquidator or the government appointed officials which are attached to it, and to the country's high court, who administers the assets and oversees liquidation. There is a gap of managing the assets once it is taken possession during the process of the investigation. Official liquidator system is completely a disaster, and the banks can also turn to a separate debt recovery tribunal, that is DRT, then partly staffed by the officials of the assignment from the bank themselves and overseen by the Ministry of the Finance. Then DRT officials have a little power to draw a line under the languishing the cases. Both are the overstretched, always they are outnumbered by teetering the pillars of the files, because there are various files, number of cases, and very limited people, knowledgeable people are available to handle the cases like bankruptcy. Presence of the multiple jurisdiction fora creates an opportunity for the debtors firms to exploit the arbitrage and to frustrate the recovery efforts of the creditor. This is also one of the tactics played, and to adversely impact the timelines for resolution process. Reform process has so far taken an approach in interim, the interim fix design to solve the problem as hands. So the judiciary process, law process, that has completely failed in timely resolving the process of the bankruptcy. That is why something new is proposed, and that something new is proposed from all corners of the financial regulators as well as from the company people also. And it is mentioned that the new code should come into the force, which consists of to bring the recalcitrant defaulters to book by empowering the creditors to initiate the process at an early stage to replace the management. So the first and foremost proposition in the new IBC is to bring the recalcitrant defaulters to book by the empowering the country. Power should be given to the creditors to initiate the process at much early stage to replace the management of the company who has borrowed the funds. It should provide for the takeover of the management by insolvency professionals nominated by the creditors, professionals to have a flexibility to bring in turnaround specialist and the consultant to achieve the desired business result, transparency. Then provides for the liquidation of the company at the earliest opportunity to minimize the losses of the debtors, and action to set aside a fraudulent transaction intended to siphon off the assets. Any delay in taking possession of the assets amounts to the losses to the debtors as well as the creditors, because its value get eroded if long time if you hold the assets without any action. And that's the why the law came into the existence, code came into the existence, which is popularly called as IBC, that is Insolvency and Bankruptcy Code, that is IBC 2016. Now, we have taken the review, after taking the review of all what is happened, what was happening, what was the pitfalls, what are the tactics played, and how the process is bundled for the inaction and time as well as recovery has a very, very minimal value. So as to improve this law was needed, and it has come to the existence in 2016. Now, let us see what is this IBC. This law, IBC, that is Insolvency and Bankruptcy Practices Law, this law is of India and it seeks to consolidate the existing framework by creating a single law for the insolvency and bankruptcy. So, single law, no other laws required to be referred. The Insolvency and the Bankruptcy Code 2015 was introduced somewhere in the December 2015. The process was initiated in the 2015 itself. Then it was passed by the Lok Sabha when it was tabled somewhere in May 2016, and the code received the assent of the President of India on 28th May 2016. That means the bill becomes the law, and finally certain provisions of the Act has come into the force with effect from 5th of August and 19th of August 2016 and thereafter. That is why when it was implemented in 2016, it is called as IBC 2016, that is Insolvency and the Bankruptcy Code 2016. Insolvency and the Bankruptcy Code 2015 provides a specialized forum to oversee all the insolvency and the liquidation process for the individuals, SMEs and the corporates also. It is not, nothing is left out. Corporates are covered, individuals are covered, and SMEs, small and medium entrepreneurs are also covered under this. This is, we are talking about the coverage of the IBC. What is new? Okay. Then this law empowers all classes of the creditors, that is secured creditors and unsecured creditors too, as well as lenders, other lenders, employees, then trade creditors and regulatory authorities to trigger the resolution process in case of non-payment by the borrowing company or borrowing borrowers, provided there is a valid claim. It also provides for the insolvency professionals to take a control of the corporate debtors. It provides an immediate suspension of the board of directors as well as its promoters, and it provides a stakeholders, that is those who have invested in that company, the stakeholders, a time to facilitate the discussion and arrive at common resolution other than running in-depth test process. So, these are some of the new ideas or new steps which are taken into consideration while drafting or while preparing the IBC Code 2016. In addition to this, this also offers a definite time limit within which debtor's viability can be assessed, and the resolution process is also agreed for the same. The power of commercial decision to revive and to liquidate the company will be on the creditors and depending upon how the court has taken up this matter. So, all these are there in the IBC. Balanced approach between the rehabilitation and recovery. There are two different aspects. Rehabilitation means it is not completely closed, giving certain additional packages and then process of revival start, that is rehabilitation. And recovery means seize the asset, sell it off, stop the company to function, get recovery, get the amount recovered which was lent, and finish of the matter. So, the balanced approach is taken care here in the IBC. That means rehabilitation and recovery, and provides a compulsory, either compulsory liquidation to the corporate debtors in the event, and if it is resolved, then it has been agreed that the entire process of liquidation has to be completed within 180 days. Sorry, not liquidation, resolution process should be completed within 180 days time. And it aims to develop a detailed and accessible information asymmetry between the various participants of the insolvency process. It provides for the clearly defined waterfall mechanism whose claim is to be first attended and who will be the last one in the row. That clearly waterfall mechanism has been implemented and proposed in this Insolvency and the Bankruptcy Code, and in the case of liquidation is happened and the assets are seized, liquidation, during the process of liquidation assets must be seized and it must be disposed of, money is to be come, and the claim on that money, how it is to be settled, that process is called as waterfall mechanism.